Judge Locke, distinguished guests, HKU affiliates, and students, good morning. Thank you so much for joining our conference on such beautiful morning. I'm sure you talked a lot about DeepSeek with your friends during the Chinese New Year holiday. Now the holiday is over, so it is time for legal and policy professionals like us to talk more about AI and explore with you how to regulate AI in the public interest. And Professor Ruth Okediji flew all the way from Boston to bring us so much beautiful sunshine to this conference. She has left all the cold snow in Boston and Harvard. Thank you, Professor Okediji. It is my distinct pleasure to introduce you a towering figure in the intellectual property field, a visionary thinker, and a tireless advocate for global justice, Professor Ruth Okediji. Professor Okediji is Jeremiah Smith's Professor of Law at Harvard Law School and currently our Chen Yitong Visiting Professor at HKU Faculty of Law. A prolific author and an inspiring educator, Professor Okediji focuses her research on the cutting-edge issues about intellectual property, innovation, and development. Her work has been globally influential in ensuring that fruits of creativity and knowledge are accessible to all, regardless of geographical and economic boundaries. I have worked a lot on intellectual property and the public interest and found her work the most inspiring. And I have benefited enormously from her scholarship on access to knowledge, access to essential medicines, and issues related to indigenous innovation systems. Beyond her academic work, Professor Okediji is renowned for her commitment to social and global justice. She has worked with international organizations, governments, and NGOs to advocate for policies that promote innovation while safeguarding the rights and interests of marginalized communities. For example, she was a leading negotiator of the Marrakesh Treaty to facilitate access to published works for the person who are blind, visually impaired, or otherwise print disabled. This treaty was concluded in 2013. Later, she was appointed by UN Secretary General Ban Ki-moon to the high-level panel on access to medicine. Last year, she led the negotiations of the Genetic Resources and the Traditional Knowledge Treaty at the World Intellectual Property Organization and successfully concluded the treaty. What a marvelous achievement. Today, we are incredibly honored and fortunate to have her share her insights on AI, IP, and human dignity. Please join me in giving a warm welcome to the remarkable Professor Ruth Okediji.
Good morning to everyone. It still feels like evening because it is evening in the US and I just got here 2 or 3 days ago. But it is a joy to be here in Hong Kong. This is my first time and I've just loved being here. The warmth, the generosity, the colors. I am so glad that I came during Chinese New Year. It's been really remarkable. We won't have too much time for the keynote, but I do hope that we will have lots of time during the Q&A to further develop and flesh out some of the key points that I want to share with you and some of the concerns that I think as a legal community, as citizens, and as part of a society that is interested in thinking about what the technological frontier should be. I hope that some of these large points will help shape the debate and will help us collectively think about what the next steps ought to be. I want to thank the Honorable Judge who's here, the team from Microsoft, and so many lawyers and practitioners and scholars who are in the room. Thank you so much for being here. Focus this morning on some high-level issues. Our conference is on regulating AI in the public interest. I'm going to focus a little bit on intellectual property, but really just using intellectual property as a window, as a prism, to look at the challenges that are ahead of us. First of all, I think it's fair to say that artificial intelligence is a broad topic. It is a technology that has really hit us almost like a tsunami. It's everywhere, even in the elevator this morning coming to the room. There are many, many workshops and conferences and debates about AI. So there will be lots of ways in which we look at this from an overview, looking at the horizon, looking at a few details, but also thinking about where we want to go. So for my purposes, we are going to just begin first with, why do we need to regulate AI at all? Why regulate at all? What's the difference between regulation and a system of laissez-faire, that is allowing the technology to just take on a life of its own, to do exactly what it might want to do? And then what does regulation mean for AI? When we say we are regulating or we want to regulate AI, what does that really mean? I'm going to talk a little bit about approaches to AI regulation, and then looking at the relationship between artificial intelligence, intellectual property, and the public welfare, and then looking finally at how and what principles we might keep in mind as we regulate AI. So why regulate? I've been struck as I've gone around Hong Kong that many of our traffic signals are the same all over the world. We have signals that tell us when to stop, signals that tell us don't enter, signals that tell us this is a pedestrian walkway, so cars should not be there, and even traffic signs that tell us which direction to go. It's a one-way, it's a two-way, it's a no-way. When we think about the legal framework for regulation, one of the key objectives is to help direct human activity. What are the areas in which human activity should be encouraged? What are the areas in which human activity should be prohibited? What are the guardrails for the development of a particular pathway? So I want to suggest to you that there are three principal reasons for regulation. The first is public welfare, human welfare. Thomas Hobbes, the famous philosopher, said the office of the sovereign, be it a monarch or an assembly, consisteth in the end for which he was trusted with the sovereign power, namely the procuration of the safety of the people. And if you are a philosopher or you are a technologist who has studied philosophy, we understand that Thomas Hobbes, in talking about welfare and talking about the safety of the people, had two principal insights. The first is, it doesn't matter what the form of government is, whether it's a democracy or a socialist democracy or a capitalist or whatever the form of government is, that the safety of the people, the welfare of the people, the well-being of the people is a principal reason for which sovereign power is given. Like, we need agencies, we need local governments, we need parliaments, various institutions vested with power to look out for the public welfare. Second major reason for regulation is justice. One of our leading thinkers, writers, authors of the Federal Papers in the US, Alexander Hamilton, in Federalist number 15, said, well, why do we have government at all? Because the passions of men will not conform to the dictates of reason and justice without constraint. Now, this is actually an interesting insight, very similar to Thomas Hobbes, who basically says, look, we need the safety of the people. Well, who are we keeping people safe from? Well, first of all, from one another. This is why we have tort law. We are in a law school, so lots of classes here that tell us that we need a lot of laws to keep us safe from one another. We also have laws that keep us safe from the things that we produce. And we have laws that keep us safe sometimes from the government. So Alexander Hamilton and Thomas Hobbes had very similar instincts that no matter what the type of government is, there's a need for safety. And then Alexander Hamilton adds, well, we also need justice. Because without constraint, without some form of regulation, we will have societies that are unjust. We will live in societies in which technologies or powers or behaviors or actions or services or goods harm human dignity, harm individuals, harm our ability to live in cooperation. So justice and just ends is another important reason for regulation. A third reason for regulation is competition. Friedrich Hayek writes about the necessity for government intervention in order to create conditions in which competition will be effective, to supplement it where it cannot be made effective, to provide services which for various reasons would not be provided at all through the market system, and that these tasks provide a wide and unquestioned field for state activity. Competition or cooperation is another reason for regulation. That in the absence of an authority that makes competition effective, or that creates conditions which would not be effectively addressed by competition, we need to have a form of intervention in the natural state of things. So when we're thinking about regulation, we are really thinking about regulatory clusters. These three reasons, public safety, welfare, competition, all break down into at least 4 regulatory clusters. One, we need government to supply public goods. Education doesn't happen in isolation. And so when we think about public good, about things like education, how do we learn? And the more learned we are as people, the more knowledge we have, the better we are able to engage in our daily lives. We need public health. We are all just emerging from the COVID pandemic. There needed to be a government institution, a central power that would help navigate the benefits of a healthcare system, public order and safety, national security. These are things that we cannot do individually. And so the supply of public goods is an essential component of the regulatory system. We also need to prevent market failure. We saw this in both Hamilton and Hayek's point, that there are certain things that the market just doesn't do well. Markets would otherwise allow monopolies. People would exercise individual power and dominate a particular field. We have information asymmetries. Many of us don't often understand the level of asymmetry that we have when we go to purchase goods. And of course, externalities. The idea that every activity generates negative costs. So for example, we're talking about artificial intelligence. Many of us understand that to create this new technology, we have to consume, or it requires the consumption of extraordinary amounts of power, of energy. Well, we also have a climate crisis. So if this new technology is generating extreme amounts of energy use, we have to think about the balance between technological advancement and the impact on climate change. So we want to prevent market failures. The third is to protect consumers. Many of us are already deeply affected by artificial intelligence, but we don't know it. And the question is, how much information should the judge have about the product that he is deciding on? How much information should you have about the products that you are using and that you're engaging with? And so consumer protection is an area of regulation that becomes important in the context of artificial intelligence. And then, of course, as I said earlier, to safeguard the environment. So one of the problems with not regulating is that it allows individuals to pursue economic interests without any benefit to the society as a whole. And so government intervention is justified. But I want to challenge us this morning in a way that I hope will stimulate our thinking about the regulation of artificial intelligence in deeper ways. Whenever the government intervenes, when it's for good reasons, even when it's because we want to supply public goods, or we want to prevent market failures, or we want to protect the environment, or we want to protect consumers, even when the government intervenes, that intervention is targeted according to a particular view of society. What makes a good life? What is just? What is good? These are decisions that drive the nature of intervention and the type of intervention that we have. The aim is to create conditions for social and economic advancement. And often, these regulatory interventions reflect what we consider to be in the best interests of Hong Kong, the best interests of the university, the best interests of our families. And these decisions are made depending on the technological state that we're already in. So what is in the best interest of Hong Kong today, view of artificial intelligence, is likely different from what the answer would have been 30 years ago. If artificial intelligence will help improve the traffic flows in Hong Kong, many of us would say, yes, let's get it in. Let's integrate AI to our traffic signals. Let's help people anticipate traffic better. Let's think about the ways that people can get from point A to point B. In the absence of artificial intelligence, 30 years ago, we may have had a different answer. So what is it that is in the best interest of traffic in Hong Kong? So the interventions that we talk about, when we talk about regulating AI or regulating anything, these interventions are designed and tailored to the type of society that we want to live in, the type of societies that we want to achieve, the type of societies that we want to promote. So I want to give you a few examples from the US, and then we're going to sort of launch into some more concrete things. In 1890, the US passed something called the Sherman Antitrust Act. And for those of you who are competition lawyers, you will be familiar with this at all. And the Antitrust Act was passed in order to curb activities that were restricting commerce across the states. The idea was that if you have so many different states within the United States, it was important that every state have an opportunity to participate in commerce. And so if Louisiana could say to New York, we don't want New York goods coming into Louisiana, and vice versa, we would create a problem in which certain goods would not be able to be accessible by citizens of Louisiana or citizens of New York. And so the Antitrust Act was meant to facilitate interstate commerce and thereby promote competition in the marketplace, because the idea was that competition, it was important for every part of the US to be able to engage in competition. Prior to the Sherman Antitrust Act, competition was regulated at the state level. And this clearly allowed states to make decisions that were protectionist, that were discriminatory, and that really excluded the capacity for the collective as a nation to be improved. Same idea behind the Food and Drug Act of 1906. We began to see in the US at the turn of the century the proliferation of fake medicine, misbranded medicine. People would sell you snake oil and call it vitamin C. They would sell you things that promised all kinds of outcomes that were not real. And so the federal government said, no, we've got to curb this. It is unhealthy for consumers to purchase a product, be told it's a pen, and then realize, in fact, it's a microphone, right? And so the need to both regulate public health and safety and to do it in a way that was efficient produce this Food and Drug Act. We did not think that it was healthy, that it was in the best interest of society to have a society that had medicines, gadgets, unregulated, and that might otherwise be unsafe. Over the course of the development of the country, and as technological advancement increased the difference between the rich and the poor, we began to implement certain kinds of social safety nets. Social Security, which basically said it was important for people to have insurance if they were unemployed. We began to see that there was the integration of technology in the manufacturing sector. That technology was creating harm to workers. And so we promulgated the Fair Labor Standards Act, which established minimum wage and maximum hours. We also prohibited the employment of children. You can see that in all of these laws, the idea is, how do we create a society that works well, a society that values human labor, human life, human dignity, a society that promotes competition so that people are able to engage in the economic marketplace, a society that facilitates national growth. And so when you think about the purpose of regulation and the historical evolution of regulation, you can begin to see very clearly that it's important for us to have a vision of the kind of society that we want in order to decide the kind of regulation that is necessary. Anybody can regulate anything. And in fact, many of us as citizens, as consumers, we are sort of fed up with certain types of regulation. It's not every time that the traffic light says stop that I really want to stop, especially if I'm running late to go to court, if I'm running late for an appointment. There are certain types of regulation. For those of you who've traveled recently, it's really annoying every time I have to get facially surveyed by the computer. So it's not all regulation that we enjoy. It's not all regulation that we think is necessary, but there has to be a sense of what's the vision behind the regulation. Why is this regulation necessary? So what does regulation mean for artificial intelligence? This is a technology that is embedded in everything from your laptops to your cell phones to your iPads to every specter of life. What can we regulate is the first question. So let me suggest at least 4 zones of regulation. The first is that we can regulate the development and the developers of AI. We can say, for example, Hao Chen, my dear friend here at HKU, should not develop artificial intelligence in the healthcare space. We can flatly prohibit that development. Or we can say you can develop artificial intelligence that diagnoses certain diseases, but you cannot develop artificial intelligence that actually cures the disease. Like there are all sorts of ways in which we can target the development itself of AI. We can instruct the developers, the coders, those who design the algorithms, exactly the parameters of that development. The second possibility is we leave the developers alone and we say, go ahead, do whatever you want to do, but we target the use. We can say to the judge, you can't use AI to write your opinion in court. We can say to parents, you cannot use a robot to babysit your children. We can say to students, you cannot use ChatGPT to write your assignment, right? We can regulate the use of AI and we can regulate users of AI. The third possibility is that we can regulate zones of activity. In every regulation, there are places of exclusivity. So there are places, as we said in the beginning of my lecture, that cars cannot go. There are places that we say people can't walk. So you can regulate zones of activity. We can say AI is good for outer space, but it's not good for terra firma. We can say that AI might be good for teachers, but not for students. There are all sorts of ways in which we can regulate the zones of activities and the places in which AI is deployed. And then, of course, the fourth possibility for regulation is the conditions of testing and monitoring. We can say, for example, before AI is deployed, it must be tested for 3 years. There must be a report on the results. And then you must monitor it every 5 years and let us know how it's performing. We can impose testing and monitoring obligations on users, on implementers, and on developers so that we understand exactly what's happening with the artificial intelligence system. So these are 4 possible ways, and we can combine any one of these ways in terms of regulation. Now, we see a little bit of this happening already in the landscape that we're in today. If you look at the European Union's regulation, the European Union has already said, we are going to be ahead of the curve. We are going to regulate this in terms of activities. We want to identify what are the risks of AI, and we want to preclude regulation in the areas that are the most risky. And the overarching considerations, when you look at what the EU is thinking about, is very much about welfare. We're concerned about safety, we're concerned about ethical development, and we are very concerned about innovation and competition. But really, the EU's regulatory framework is very concerned about the development and the deployment and the use. It is all embracing. Japan is very much in the zone industry. So if you look at the Japan guidelines, business use is where it's targeting, not so much personal use. So if you are a parent and you have a 5-year-old child and you employ a robot to take care of your child while you go to work, the Japanese focus has not really penetrated private use. It's very much focused on business use. In Singapore, similarly, very much focused on business and government use. And in the UK has developed a very light touch approach. But you can see that for all of these countries, there is some sensitivity to how we approach the regulation of AI. Not a single country or region in the world is saying AI should just emerge and be developed without constraint. Everyone wants to regulate it, and the question is how, when, and what. So let me suggest to you that there are at least 2 big regulatory frameworks that one might employ: private law frameworks and public law frameworks. And they're not mutually exclusive, but they do have different ramifications for the type of country, the type of society that we want to be. One of the things that I want to start with first is that when we think about hard law, we really only have 2 regions that have led the way. That's China and the EU. We have very clear statutes that tell us the government's concerns about artificial intelligence. In some countries, most countries, what we have are guidelines, principles, suggestions, but no hard law. So China and the EU, we see, are leading the race in terms of very strong statutory regulatory frameworks. Japan has guidelines, Singapore has a strategy, and the UK says, we're looking at the sectors and we want to regulate sectors. Then, of course, there's the global AI initiatives by the OECD and the United Nations, but these are what we call public law models. These are models that are really targeting the possibility of shaping the development of artificial intelligence and its use in public life. The development of artificial intelligence and its use in public life. Private law models are very different because private law models are really focused on existing legal regimes that already regulate human interaction. And the question is, can we use these existing regimes to regulate the way artificial intelligence affects my relationship, my interaction with you, my relationship, my interaction in the marketplace? So privacy law, contracts, tort law, corporate governance, competition law, and of course, intellectual property law. These are ways of not only private law models, but they're also indirect regulations. They indirectly regulate the ability to use AI and the way in which we might develop it. So here are some advantages and some disadvantages of these models. Now, before I begin to delve deeply into this, let me just say this. Even though there's been a lot of attention on the regulation of AI, there has been very little attention on what happens if a company develops an AI system that violates the law. Not a single country has said, well, we're going to imprison the CEO of OpenAI if it violates this law. And for all of us as lawyers in the room, for the judges in the room, we understand that the legitimacy of the law and the power of the law is in the sanctions that are associated with the violation of those legal norms. And so I think we should pay attention to the reality that even though we're talking about the regulation of AI, and even though the public models of regulation have given us a lot to talk about, it's unclear what it really means in terms of shaping the advancement of this technology and shaping its impact, because no one knows, well, what's the consequence if I violate what the standard is? If I create an unethical AI, what's the consequence? And so when you look at these public law models, legal certainty is an advantage, global or universal protection. It ensures accountability of powerful market players, and that has its advantages. Private law models are flexible and adaptable. They encourage innovation. You have a market-driven accountability. Private law regulatory models allow customization and industry-specific solutions, and of course, lower compliance costs. And this is important, I think, for the major players. The problem, of course, that we're seeing is that we're not really regulating AI. That's not really what we're regulating. We are regulating its deployment and what it can do. This is a stark difference from what we do in intellectual property. You know, in intellectual property, for those of you who are creators and coders, we never say to a computer scientist, you cannot create a computer software program that does X. We never do that. In intellectual property, let 1,000 flowers bloom. We simply leave it up to human creativity. You decide what you want to create, and then we give the standards for whether you get a copyright or a patent or a trademark. With artificial intelligence, these efforts at regulation are doing the exact opposite. These efforts at regulation are saying, we are concerned about what you are doing, and we're concerned about how you're doing it, and we're concerned about the public interest. And what's ironic about this is that of all of the private law models of innovation and regulation of AI, it's only in intellectual property that we have an explicit concern about the public welfare. When we think about the welfare interest in intellectual property, it's because we have a fundamental belief that innovation is supposed to promote the public interest. And so ultimately, we are thinking very much about the role of intellectual property as a private law model for the regulation of AI. What does that mean? Well, it means we have to understand why intellectual property. We know, for example, that copyright plays a significant role in the generation of these large language models, in the training of these large language models. But the reality is that the utilitarian framework for intellectual property is anti-regulatory. So we already have a conflict between the idea that intellectual property is a model of regulation of AI and the idea of regulating AI as well. In addition, there's very little ex ante or ex post regulation of innovation. TRIPS may preclude any hard regulation of creative activity. Those of you who are IP students and IP lawyers in the room, you may recall that in the TRIPS agreement, there is a prohibition on countries defining limits on creative activity. It is very much anti-regulatory. So the notion that IP can be a regulatory lever in IP and in AI is really important. And so my observations in conclusion are as follows. Our welfare considerations are going to be sector specific. The way we regulate AI in healthcare, in employment law, in innovation, in the movie industry will look very different. We have gone past, Winnie and I were just mentioning with the judge before we started, the speed of deployment of AI is exponential. We are beyond this idea that we're going to pull it back and start to regulate it. We all have to come to terms with this. So it has to be sector specific. And we have to begin to think about what are the normative or doctrinal frameworks in which we're going to do this. At the moment, the unregulated nature of AI means that private investment in the development of AI is actually flowing in the places where we do not have regulations. So copyright offers some possibility, but as I said, copyright is not good. Copyright does not give us any hope that AI is going to be effectively regulated. There are too many problems with copyright and with IP in general. And as I said, there's an instinctive anti-regulatory impetus in the IP field in general. Most importantly, we really don't know before it's developed whether this IP is going to be conferred or not. So my view is that intellectual property is not the best place to think of regulating artificial intelligence. I think it's not going to be effective and it is unlikely to work. So what are some possible modalities as I wrap up? One is to treat artificial intelligence the way we treat the environment, impose a tax on developers. So if you are creating artificial intelligence that's going to affect national security, the tax is going to be really, really high. We may even prohibit it. We have an example of this in intellectual property. We do not preclude people from innovation in nuclear power, but we do not allow those who innovate in nuclear technology to simply go to the market with it. So we could treat AI the way we treat the environment, just put a tax on it. A second possibility is we could increase the amount of information consumers have. When we began to realize that smoking was bad for people's health or alcohol was bad for people's health, what did we do? Governments began to flood the market with information. Don't drink too much, don't eat too much sugar, don't eat too much salt, don't eat too much of this and that. We begin to flood the market with information so that consumers are empowered to make better choices. This is a possibility. A third is to strengthen consumer protection policies. Many people do not know when they are engaging with AI. And perhaps if you knew, you would make different choices. If you knew what your picture was being used to do, if you knew the data was being scraped about your activities, you might make better choices. And so consumer protection might actually be a model that could be helpful. We could also ask developers to disclose the source of data. Did you get your data from the judge with permission? So there is a large language model that is being created for every judge, so that the next time the judge is going to sit and listen to a case, the AI has already predicted, this is how he's likely going to rule. Make your argument this way instead. This is how he might rule. Make your argument this way. And if the judge were aware of that, the judge could say, I do not want you using my opinions to train your language model. The fourth is we could treat AI like we do medicine, pharmaceuticals. For certain types of AI, we might want to have an agency that approves its release to the public. So before it's even released, an agency has to evaluate it for its efficacy, for its trustworthiness. And finally, of course, we could think about competition in AI development. I think as I wrap up now, it is important that no matter what the models are for regulation, if we are thinking about a society in which human beings are going to be the focus and the protection of human dignity is going to be our guiding star in how and why and when we regulate, it's going to be important to understand that the world trade system is critical. And I say this, of course, with DeepSeek having just been released and with all of the conversations that are going on about this. AI systems are going to impact trade, and trade rules are going to become exponentially important in regulating AI. Global competition pressures on AI will be significant, and if AI is going to be embedded in the global trade system, this is going to increase competition for the development of more AI systems. We're going to be in an AI race. And if we're going to be in an AI race, there's going to be pressure to deregulate, not to regulate, because that's what competition does. That's what global competition does. It is a force for deregulation, not regulation. So I think, in conclusion, we have an extreme amount of work in front of us, especially as lawyers and as judges. And really, that work includes education, but it also includes beginning to think about what are the consequences. We know already that this technological frontier is outpacing anything we have seen to date. We know that the amount of data that it takes to train the algorithm is being sourced both legally and illegally. We know that intellectual property cannot constrain it effectively. And we know that there will be pressure to deregulate because of geopolitical tensions and because of global competition. So for lawyers, for policymakers, for judges, we have essential questions that we must ask. Who is this technology going to affect the most? Who's going to be left behind? What kind of institutions do we need? And can artificial intelligence really promote the public interest if it is not human-centric? Thank you very much.